Commissioner, do you want to elaborate that we actually changed a policy because of the threshold size of some of these claims? We had a conversation about that.
Well, I think Mr. Tipton raises a couple of issues, and I think we mentioned earlier, by matter of policy, large claims like this one, and there are several more that follow, will automatically have a discussion, because I think the board's position was they are matters of importance that the public needs to understand. I guess the other side of that is I feel frustrated because our hands are tied, and I think there was earlier discussion about discretion. Frankly, given the legal rights for recourse by owners that are denied, I don't think we have discretion. That's my personal view. And my wife was complaining to me this morning when I woke up at 3 a.m. thinking about these and some other items, and she doesn't appreciate my grouchiness. And and I think rightly so. These things are not taken lightly. On the other hand, we follow the law. And I think you raised some interesting questions as people are starting. First of all, the timeline for making claims is winding down. So we're going to see, I think, a sharp upturn. We see that today. I also think larger claims are coming in. A lot of people have been holding off to see what the lay of the land is. And I guess the most we can do is be honest and straightforward about what this is. And there will be those who see it as progress and those that see it as awful and some in between. And I don't know, I guess I used to be a psychologist. I used to tell my patients, Epictetus said, 4th century BC Greek philosopher, nothing is good or bad, but thinking makes it so. I'm not quite sure that's accurate, but thinking can sure make it a heck of a lot better or worse. And I think a lot of us are spending a lot of time thinking about it. So our situation is the law seems pretty straightforward, at least in terms of our claims. How this is ultimately adjudicated, many of these decisions will be going to the Supreme Court, I think. But already, you'll remember, it was set aside for a period of time, and I think it probably not the correct way legally, but it was unilaterally overturned by the Supreme Court. So we're in the midst of this. Commissioner, do you have something?
Yeah, I actually had a question of staff, Commissioner, because you talked about the timeline for making claims winds down. But my understanding is, I'm not sure I'm clear on this, someone can still come in with a request for development, and if it is at the Planning Commission level turned down, they can still move forward with the Measure 37 claim. That it's kind of a timeline, but it isn't. Well, it really won't stop this Measure 37 from still being implemented or people coming forward with claims.
There's a couple of things. One issue is whether or not the time that has been declared unconstitutional, i.e. the time between the circuit court decision and when that was reversed by the Supreme Court. Some people think that adds on an extra, I think it's 4 or 5 months to when you can file claims. Then what you're referring to is the measure says you have 2 years from the time the measure is enacted, or when, to paraphrase, when the zoning is enforced. And the zoning probably is enforced anytime somebody comes in and applies for something they can't get, and the county says, well, you can't have this, then probably, or at least arguably, you're enforcing the zoning ordinance at that time, and you start a new 2-year calendar running.
So you could continue. So we would expect these claims to continue then, even though there is ostensibly there's
sort of the most popular theory, but again, one of the many things we don't know for sure.